you want to come and grab more food, something to drink, feel free to do so. Lord knows we have plenty of food. I might have overestimated how much food we actually needed, so please take some more. Thank you all for coming out to our last event for this semester for Federalist Society. I want to thank the Health Law Society for partnering with us. Thank you guys for co-sponsoring. Today we have Professor Josh Blackman from South Texas School of Law. Professor Blackman is Associate Professor of Law at the school. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman graduated from Penn State in 2005 with a Bachelor of Science and graduated from George Mason Law, now in the Anton Scalia School of Law in 2009.
Didn't change my diploma though.
Probably not.
Nope, no new diploma.
Right. So Professor Blackman is just going to talk about the repeal of the healthcare law in Texas, as well as sort of what it means to have, whether or not you can have government mandated healthcare under the Constitution. So we'll go ahead and get started. Thank you.
Thank you so much. It's a pleasure to be at Villanova. You have one of the better health law programs in the country, so I'm sure you're all ready for me with lots of good questions. The saga of the Affordable Care Act can be told in 3 acts. Called Act 1 Unprecedented. In 2010, a sharply divided Congress required most Americans to buy insurance. 2 years later, in NFIB versus Sebelius, a sharply divided Supreme Court found that Congress lacked the power to enact this unprecedented individual mandate to buy insurance. They couldn't do it under the Commerce Clause or the Necessary and Proper Clause. However, a saving construction was used. Chief Justice found a way to construe the law's penalty as an exercise of the taxing power, so most of Obamacare was saved. I call Act 2 unraveled. Between 2012 and 2016, congressional Republicans tried over and over and over and over again to repeal and replace the Affordable Care Act. But so long as President Obama wielded the veto pen, these efforts were doomed to fail. But the attempts to unravel the ACA were not limited to Congress. After the first round litigation failed, conservative groups brought new challenges to block the ACA's payments of subsidies. If successful, millions of Americans would no longer be required to purchase insurance. There'd be no penalty for going uninsured. However, the Supreme Court once again turned away the challenge. This was a case of King v. Burwell. By the way, my first 2 books about the ACA were called Unprecedented and Unraveled. Trilogy coming soon. The third stage, the third act, I call Undone. Following the 2016 election, Republicans now control the White House and both houses of Congress. There were efforts to repeal and replace Obamacare, but most famously Senator McCain gave it the thumbs down. I'm still talking about that thumbs down, still angry about that. But they did something else. Congress enacted the Tax Cut and Jobs Act of 2017. Now this bill did a lot. It modified our tax code in substantial ways. I'm not here to talk about that. I'm here to talk about a single aspect of that bill. The Tax Cut Act did what NFIB and King v. Burwell could not do. It eliminated the penalty for going uninsured. Okay? It did not repeal the mandate, and this is actually a fairly important point. It only set to $0.00 the penalty for going uninsured. But with this act, the core of Obamacare was basically undone, hence the title. But when this happened, something changed. Right? And I realized this, maybe you did as well. The premise of Chief Justice Roberts' saving construction was now in flux. Could a penalty of $0 still be saved as a tax? Well, this occurred to me and occurred to Texas, where I live. And the Texas Attorney General brought a new constitutional challenge to Obamacare. argument was this. Now that the individual mandate no longer raised any revenue, they argued, the so-called shared responsibility payment could not be saved as a tax. Therefore, the mandate was unconstitutional. But they didn't stop there. They brought back the arguments in the first round of the Obamacare litigation. And they said, if the mandate goes, then all of Obamacare has to go. That you can't sever or cut off the mandate, right? Imagine it's a gross analogy, but imagine you have gangrene on one of your toes, right? Do you just cut off the one toe, or is a foot so infected you have to amputate the entire foot? It's a gross metaphor, but it actually describes the imagery of severability, right? Can you just cut off the bad part, or is the entire organ so tainted you have to get rid of the entire thing? Texas argued that the entire law has to go. So they sued the federal government. The federal government then took something that was surprising, not surprising to me, but surprising to a lot of people. And they decided to agree with Texas in part. Attorney General Sessions released a memo. And that memo said, we agree, Obamacare's mandate is no longer constitutional. But they didn't go along with the remedy. They said, you don't have to cut off the entire foot. You just cut off 3 toes. You cut off the mandate, you cut off what's called guaranteed issue, and you cut off what's called community rating. What are those two things? Community rating and guaranteed issue. These are the regulations that require insurance companies to issue a policy to anyone, no matter how sick they are. And they have to price it, not based on the person's health conditions, but based on how a community rating would work, right? If you live in this community, in the zip code, and you're of a certain age, what then is your cost? And DOJ said, if you kill the mandate, you gotta kill GI and CR. I'll just use GI and CR because it's less of a mouthful. And they didn't actually make this argument up. This argument was first advanced back in 2012 by the Obama Justice Department. And they told the Supreme Court, if you guys kill the mandate, you also have to kill the most popular part of the law. Swallow that poison pill, right? The pre-existing condition protections. Now, the Supreme Court upheld Obamacare's mandate. They didn't have to resolve the issue of the severability. But DOJ's position was surprising, but it made very little impact on litigation. Why? New Jersey and several other blue states intervened to defend the AAC in its entirety. Okay, so we are in Act 3 right now. That's what I want to focus on primarily. We don't know how this act ends. A lot of pieces are very much in flux, but I want to walk you through the history of the ACA, the history of Chief Justice Roberts' saving construction, and give you a little bit of an update. We got some breaking news just 2 days ago on the ACA front. So the first part of my talk considers how the ACA operates. Okay? You have 2 separate components that are relevant. You have the individual mandate, and you have what's called the shared responsibility payment, the shared responsibility payment. A lot of people conflate these two, but they're distinct statutory provisions. Okay? The individual mandate says you shall be insured, right? The Supreme Court said the most logical way of reading this is a command. You shall buy insurance. The shared responsibility payment penalizes those who do not maintain insurance. And the amount fluctuated based on income, generally about $700 plus or minus. All right. Why is it important to separate them? Because these are distinct legal concepts. Some people are exempt from the mandate, right? For example, if you're not here legally, right? Or if you're incarcerated, right? You don't have my insurance. So Congress exempted some people just from the mandate. And there are other people that Congress exempted from the penalty. For example, if your income's below a certain threshold. That is, if you're poor, but not that poor, but if you're in this little band where you can't qualify for Medicare, you can't qualify for Medicaid, but you're not that rich, you're in this little band, you're still subject to the mandate, but you're not penalized. Why is this fact important? Congress understood the mandate and the penalty to operate separately. They're interrelated, to be sure, but they're separate provisions. Indeed, Congress wrote what are called legal findings, right? These were part of the bill to explain why different parts function the way they do. And Congress said in several places the mandate was, quote, essential to the operation of the ACA, including the GICR provisions. The mandate. They said nothing about whether the penalty was essential. Okay? This is important. Okay. Now let's talk for a minute about NFIB versus Sebelius. I'm sure you all read this in common law or in health law. It's a long opinion, 100 and something pages. Every time I read it, I keep hoping it comes out differently. Hasn't happened yet, but I'll keep trying. Chief Justice Roberts' opinion is hard to parse. Okay? He was willing to uphold the mandate under Congress's taxing power. Why? Because the shared responsibility payment, that is the penalty, had three characteristics. And I'll call these three characteristics guardrails. It'll make more sense why in a minute. First, Roberts wrote, the penalty is paid into the Treasury by taxpayers when they file their tax returns. In other words, this penalty is paid to the IRS. April 15th is coming up real soon. You attach the penalty with your tax return. Okay. Second, Roberts wrote, quote, for taxpayers who do not owe the payment, its amount is determined by such familiar factors as taxable income, number of dependents, and joint filing status. In other words, the penalty is calculated the same way other taxes are calculated. Again, Robert's saying that, look, this isn't actually a tax, but it resembles a tax. Third, Roberts wrote, the process of making the payments, quote, yields the essential feature of any tax. It produces at least some revenue. Produces some revenue for the government, right? Taxes raise money, that's what they do. Roberts looked to these three, I call them guardrails, as the reason why the penalty in the law could be construed as a tax. And if the penalty is a tax, then there's no legal command, right? The actual holding of Obamacare was not that the mandate was valid, and just this is a point people don't actually get. The holding of Obamacare, of NFIB, was that there is no mandate. There's merely a tax on going uninsured. What? Say one more time. There was no actual mandate under the saving instruction. There was merely a tax on going uninsured. And Roberts said this is perfectly fine. Congress can tax people all they want for doing or not doing anything. Everyone agree? Okay. So now let's move on to 2017, the Tax Cut and Jobs Act. It was a huge bill. Most of the provisions are completely irrelevant for my talk, but it did one important thing. Starting in 2019, now, as we speak, right, live, the shared responsibility payment was set to 0. Okay? Congress did not repeal the mandate in Section 5000A. They didn't have the votes to do it. And indeed, this is a point people don't quite get. They use something called the budget reconciliation process. What's budget reconciliation? It's a way of passing certain fiscal measures that eliminates the filibuster. Right? Usually in the Senate, when you pass a bill, you need to hit the 60 vote threshold for a cloture. But the budget reconciliation process doesn't need 60, only needs 50. Indeed, this was how Obamacare was passed in 2010. Democrats didn't have a filibuster majority anymore. They used this reconciliation process. But there's a limit. You can only use reconciliation to modify fiscal provisions. Congress could not have repealed the mandate through the process they chose. They didn't have the votes for it. Congress also could not repeal the findings about the mandate. They couldn't repeal the findings that the mandate was essential. This is important. So the law still has the mandate and still has the finding saying that the mandate was essential. But what they did do was they dropped down to $0.00 the shared responsibility payment. Now you can think, wait a minute, Josh, what the hell's the point, right? Why would you have a mandate with no penalty? Isn't it toothless, right? That may be intuitive. I think as a practical matter, that's probably right. But for some people, a legal command, even one that's not enforced, still has weight. It still has merit. Now, don't take my word for it, because God knows I'm, who am I to say? In 2008, the Congressional Budget Office said, personal values and social norms, apart from monetary penalty, enforce compliance with the requirement to buy insurance. Again, social norms and personal values. Matter of ethics. People say, I'm going to follow the law. In 2017, the Congressional Budget Office released a report. And they said, I'll read this for you, quote, with no penalty at all, only a small number of people who enroll in insurance because of the mandate under the current law would continue to do so solely because of a willingness to comply with the law. Again, a small number of people, not zero, but some people, CBO found, would still comply with the mandate even in the absence of a penalty. Some people, these righteous individuals, right, still think the mandate has weight and will comply with the law. And again, you don't need to take my word for it. In the litigation in Texas, where I'll get to in a minute, individuals, plaintiffs, Texans, said, I still feel compelled to buy insurance because of this mandate. Maybe they're right, maybe they're wrong, but generally we take well-pleaded complaints, well-pleaded facts to be true, at least at this stage. Maybe we can depose them and prove otherwise. Those are facts that we take as true. And I say, wait a minute, Josh, what's the injury? What's the injury? You're not paying a penalty? Who cares? Is this just in your head? Well, let me put it this way. There's an easy answer and a hard answer. I'll do the easy answer first. Have you all done your taxes yet? I'm almost done. Let me tell you, when you do your taxes, it's going to be a question. You're going to say, did you buy health insurance for 2018? All right, you all know this question? If you check yes, okay, that's the end of the road. If you check no, you have to fill out some of the forms. Guess what? That's an injury, right? The government still wants to know if you buy insurance. Why? It's actually tricky. Let's say your employer says, oh yeah, I gave Josh insurance. But you say, no, he didn't, I was uninsured. Okay, they're coming down to the employer, he lied. They still need to know that individual coverage to cross-reference the employer mandate, which is still in effect. There's an injury, right? I think that's an easy case. I've had anyone tell me yet why that's not an injury. Now, this form doesn't exist yet, right? It won't exist probably sometime later this year. You have to plan for it. You have to anticipate what your tax return will look like. You can do quarterly payments. That's not a hard one. Now, the harder ground for standing, which I think is much more dubious, which I don't put all my weight on, but I think a legal command by itself has a moral force to it that compels people to do things. It's not conventional. There aren't many commands in the US Code that make you do something, that don't have anything backed up to it. But I can draw analogies to the Establishment Clause context. If I walk past a 10 Commandments display, what's the injury? Bothers me, makes me upset, right? I feel that government shouldn't be endorsing this type of religion in the public square, whatever it is. At least in the Establishment Clause context, standing can be very fluffy, and I think that might be a basis. But I don't need to rely on that. I think it's a good academic question, but the tax return seems pretty rock solid to me. Okay, so assume, for now at least, that there are some people who still feel compelled, and they have an injury. You don't have to agree with me, but at least for now, at the pleading stage, I think it's a good enough argument. So then, what's the argument? They argue this. After the Tax Cut Act, the individual mandate can no longer be saved as a constitutional tax from the uninsured. Why? The requirements to purchase insurance now fall outside the three guardrails identified by Chief Justice John Roberts. So first, starting in 2019, 0% of Americans have to pay the penalty. No one. All of you are now free to go uninsured. Indeed, my students before chose to pay the penalty. They said insurance was too expensive. I'm sure some of your friends do the same. Okay. Smart choice not, no, I'll let the few decide, but people do it. Second, taxpayers will not owe any penalty for their 2019 returns. Again, most people filed their 2019 returns in 2020, so we don't have the forms yet, we'll have them soon. And third, as a result, the penalty will no longer produce any revenue for the government. A $0 penalty produces zero revenue. Okay? That's the argument. It's pretty straightforward. And I think most people will agree, not everyone, that in the abstract, the mandate can no longer be saved. Now, they argue about standing otherwise, which I think is all well and good. But the argument, if you want to take Roberts seriously, and I do take him seriously, the mandate is no longer constitutional. Right? So for that reason, I agreed with the Attorney General's decision not to defend the mandate anymore. I think he was correct. I think the AG has a duty to decide the constitutionality of statutes, and under an FIB, a $0 penalty cannot be saved. I agree with Sessions on that. I don't agree with the other parts. So let's turn to the next aspect, right? If Obamacare's mandate goes, what happens? Do you just sever the pinky toe? Do you sever 3 toes? Do you sever the foot? Do you sever the leg? Or do you execute the patient, right? How much do you have to cut off? And that's the question of severability. So I think there are 4 possible options. Option number 1, go number 1. You only kill the mandate, right? You say the mandate's unconstitutional and the executive branch, you cannot enforce it. Okay. I take that as a moral victory, right? I think that would be a victory for the separation of powers. The court said that this statute is unconstitutional, you can't enforce it. As a practical matter, not much would change. They're not enforcing it anyway, right? They're not actually enforcing the mandate. But I think it would affect at least people who feel compelled, like the Texans I mentioned earlier. That's door number 1. Door number 2 is you chop off the entire leg, or the entire patient, depending on how you define it. That's where the entire ACA should be halted. Everything. The mandate, the Medicaid expansion, pre-existing condition protections, regulations on posting calorie counts at restaurant signs, right? There's a lot of stuff in Obamacare. The thing was like 3,000 pages long, and there are tens of thousands of pages of regulations that have been enacted since then. Okay? So that's option number 2, right? You kill the entire law. Option number 3 is a little trickier. All right, by the way, let me go back to option 2 for a minute. This isn't so crazy, right? When NFIB was argued, remember the court split 4-1-4. The 4 joint dissenters, it was Scalia, Thomas, Kennedy, and Alito. The 4 joint dissenters, they chose door number 2, right? They argued that the mandate was unconstitutional and that the law couldn't function without the mandate, right? That the entire reason the mandate existed was to draw people into the marketplace, and if people weren't being drawn into the marketplace, all these other provisions couldn't sustain themselves. They made a judgment of what Congress would have wanted. Maybe they were right, maybe they were wrong, I don't know. So the position that the entire ACA must go was really the joint dissenters' position back in 2012. So it's actually not insane, but it's a position. Okay? Let's go into door number 3. Door number 3 is you cut off the pinky in the middle and the thumb. The big toe, what do you call it? The thumb toe, I don't know. Door number 3 is you strike down the mandate and the guaranteed issue community rating provisions. Again, these are the protections for people with pre-existing conditions. This was the argument advanced by the Obama Justice Department. right? They told the Supreme Court, if you strike down the mandate, Supreme Court, guess what? You also have to kill the most popular aspects of the law. Now, there's a legal argument. Why? The reason why Obamacare can protect sick people, on paper at least, is because of the mandate. It says everyone has to buy into the marketplace, so that way everyone's insured. What you can't do is wait till you get sick and then sign up for insurance, because then your bills will be super high. That's a theory, at least. It never actually worked. The mandate was never effective at getting people into the marketplace. I think the penalty was far too low. So people still waited till they were sick and bought insurance. It didn't really matter. But in theory, at least, they warned of the so-called death spiral. Now, this is not a metal rock band. Death spiral refers to this phenomenon where only sick people are buying into an insurance marketplace, health people stay out, premiums go way high to cover those costs, and then the entire thing implodes. States like New Jersey, which had employed a guaranteed issue policy but not a mandate, had serious problems. By the way, that's what we have right now, by the way. We've basically repealed the penalty, so we have guaranteed issue but really no effective mandate. Why is Obamacare still functioning? Subsidies, right? When you go buy a policy, if your particular care is more expensive, the government will subsidize it, put more money into it. That's what's keeping Obamacare afloat. It's not the mandate. It's lots of tax money flowing into the coffers of insurance companies, right? Most people don't even see it. They don't even touch it. It goes indirectly. So in 2012, the Obama administration said, aha, if you kill the mandate, you got to kill GI and CR. That's door number 3. But now, let's just take a step back and think about this for a minute. Should it matter what Congress intended in 2012 anymore? This, I think, is the strongest argument in favor of the challengers, and one I have to debate on quite a bit. Why should we care what Congress thought in 2012? Why should we care what Obama thought in 2012? Shouldn't what matter the actions of Congress in 2017 by enacting the Tax Cut Act? In other words, we can just forget about whatever Congress thought back when ACA was passed in 2010. What matters is how the ACA functions now with a $0 penalty. And this is the position advanced by most law professors. I think it's a strong position. I'm not really persuaded by it. I do think it's a strong position. Let me walk you through this one step at a time. In 2010, Congress said the mandate was essential to the operation of the law. Hindsight's 2020, it wasn't. The mandate proved not to be very important. It was actually the subsidies that were important. And Congress acted on that assumption. They zeroed out the penalty. They made it $0, effectively showing that you don't need the penalty for an effective healthcare marketplace. I think you can approach this in 2 different ways. The first is that Congress only acted on the penalty. They didn't act on the mandate. If Congress wanted to make it clear the mandate was no longer essential, they could have repealed the mandate, and they could have repealed the findings about the mandate. And they did neither, and because of budget reconciliation, they could do neither. So I think we're still left with a statute that has a mandate and findings saying that the mandate are essential. And I think nothing to serve that. I agree. In 2017, Congress thought the penalty was not effective, but they did nothing to say anything about the mandate. And I would rather focus on actual text of a statute than try to divine from the aura of legislative history what Congress would have done but didn't have the votes to do. But there's another way of looking at it, I think leads to door number 4, which is the most peculiar of all the doors. If we start from the premise that what Obamacare, let's start from one premise. The ACA was only constitutional if the law raised revenue, the mandate raised revenue. Okay, that's what Roberts said. The ACA's mandate was only constitutional if the penalty raised revenue. Congress said, hold my beer. Right? Congress said, no, we're not going to do that. We're going to kill the revenue. They said, John Roberts, we don't care. You said it's only constitutional if it raises revenue. We're going to ignore you, and we're going to zero out the penalty. Now, generally, forget about Obamacare. If a court says this law is only constitutional if X happens, and the legislature says, screw that, we're going to do the opposite of X, that's bad, right? They basically ignore the Supreme Court. They took an unconstitutional action. They took a statute that was constitutional and they made it unconstitutional. What is the remedy when a legislature takes an act that's unconstitutional? You know the answer. You set aside the most recent action. Bear with me here. If we take seriously the idea that the Congress in 2017 made Obamacare unconstitutional, the remedy is to strike out the tax cut. It's to restore the penalty. Follow me here? The remedy is to restore the penalty. Make it back $700. You restore the constitutionality of the statute. Now, I actually think, again, this is a statement against interest, that if we're just looking at this purely theoretically, the correct remedy would be to kill the tax cut, to restore the penalty, make Obamacare great again, right? to restore the $700 penalty. That would make everything fine. The case would vanish. Now, I don't think that's an option in the current litigation. Let me explain why. Courts don't have the sort of blue pencil to strike out any part of the law they want. They can only consider parts of laws that were actually challenged. No one challenged the tax cut in the Texas litigation. No one challenged it. They only challenged the mandate. So I don't think in the Texas litigation that option number 4 is on the menu, so to speak. I don't think it's one of the possible range. Now, Maryland filed a lawsuit, and Maryland did assert that the mandate penalty and the tax cut were in conflict, and Maryland said the tax cut should go. I think that's a viable option. Now, the court will be confronted with a choice. How do we reinsert a tax that people didn't pay? Do we start sending people bills, right? Guess what? You're all in violation of tax law. Go send you a delinquency notice, right? Charge interest? I don't know. So none of those options are particularly attractive. I would be just as happy with option number 1. All right, so now I think I've walked you through the entire case. Let me bring you up to speed with where we are in the litigation. In December, 3 months ago, a federal judge in Fort Worth issued a decision. He found, first, that the mandate was unconstitutional, and second, that the mandate cannot be severed from the rest of the ACA. He cut off the leg. Right? This was the option from the joint dissenters and NFIB. The entire ACA must go. But this is important. He did not issue an injunction. He merely issued a declaration. Why is that important? Because as it stands right now, Obamacare is in full effect. Nothing changed. And I want to make this point very bluntly. Even if the Supreme Court upholds his decision, the case still goes back to the district court to decide what the remedy is and how long it'll take. So this case might be with us for years to come. Maybe not, I don't know. But we don't have an injunction, which is important. So the case then was appealed from the district court in December, and it's now on its way to the Fifth Circuit. Not on an expedited basis, actually on a fairly slow basis, a fairly drawn-out, non-expedited appeal. New Jersey and the blue states, they appealed. And also we have an intervention from the House of Representatives. After the 2018 election and the Democrats took the House, they decided to intervene. And indeed, they retained a lawyer named Donald Verrilli. Verrilli was the lawyer who defended NFIB in 2012, and now he's defending the law again. So perfect for my 3rd book. The trilogy completes itself. But then I go to the Jar Jar trilogy, go back in time, right? But we'll start at least with these 3. But then we got something funny 2 nights ago. It's hard to surprise me. I've seen everything. Nothing actually surprises me anymore. This surprised me. Was it yesterday? 2 nights ago. On Monday evening, DOJ's brief was due to the court. And I expected them to argue that the district court decision should be affirmed in part and reversed in part. They said, we're going to agree with him on the mandate, but you don't have to cut off the entire leg, just cut off a few toes. Right? That was DOJ's position all along. And instead, they submitted a 2-page letter. A 2-sentence letter. I wish it was 2 pages. It was a 2-sentence letter. And the letter said, LOL JK. No, basically, we agree. The district court should be affirmed in its entirety. All of it. All of Obamacare has to go. So in other words, we will file a brief with Texas. We're basically now on the same side as Texas. The entire Obamacare has to go. Again, it's hard to surprise me. I've seen everything in this litigation. It's gone back and forth, up and down, left and right. But this actually surprised me. I was like, wow, did not see that coming. And the reason why is that generally, what is generally? Generally, DOJ has a duty to defend as much of federal law as it can credibly do, right? Not always. There are instances where if an administration decides a statute's unconstitutional, they say we're not going to defend it. Or they think that an argument in defense of a law is frivolous, they're not going to defend it. I agree with Sessions on the mandate. I think there's no good argument the mandate's constitutional, it's got to go. I disagree with Sessions on the severability about just cutting a few of the toes off. But I think it was a reasonable position. It wasn't right, but I think it was plausible. There's a good argument that this was the same position Obama took, and nothing in 2017 changed that calculus. But I'm struggling with the decision to cut off the entire leg. I'm really struggling with that one. And I actually have a op-ed in the the Washington Post coming out today or tomorrow on this exact question, where I criticized DOJ. In other words, how did Attorney General Barr, the new AG, come? He's been busy, right, with the Mueller thing. Now he's this. How did he come to this conclusion? And the story may be a little bit murky. Politico just last night had a report which says that Attorney General Barr didn't want to do this. And the White House said, you're going to do this. You can figure the finger pointing, right? You'll do this. The policy people who want to kill Obamacare said, you're going to take this position. So I see a problem, right? This is great for my book, but I think bad for the rule of law. I think we have an issue here. DOJ usually stands in a fairly unique position in the separation of powers, right? Courts give them certain, I'll say deference, credibility, accountability, right? When DOJ makes an argument, it's different than when a lawyer at a private practice firm makes the argument, right? There's some institutional credibility behind that statement. Okay? But now, we basically have evidence that the White House wants to burn Obamacare to make something great again, right? They want to just burn it down so new law can rise from the ashes. The courts aren't going to respond well to that. I never thought John Roberts would accept this challenge from the outset. He always breaks my heart, always. So he's going to rule against this. But you burn bridges, right? If Trump starts doing stuff that's bad and his DOJ starts doing bad stuff, the courts, they shouldn't, but they'll probably retaliate in kind. And I don't like to say it, but I think it's invariably true. So ultimately, this sort of move by cutting off the entire leg, I think is counterproductive. I really do think it is. I think it will weaken the Trump administration's standing even more so than it already is and make it harder to win other cases. But none of that may matter for this case. I still think, and call me crazy, that the Supreme Court, in the end, will say that the mandate's unconstitutional, but we'll leave it there. And I will take that as a moral victory, that the separation of powers matters, that Congress's powers are limited, that the saving instruction was not a political farce, maybe it was, but at least we'll say it has merit. Indeed, we have a new book out called The Chief by Joan Biskupic. She interviewed Roberts and most of his colleagues, and she wrote this book. It's remarkable. She confirmed a lot of the stuff in my book that I didn't have in nearly as good authority, that Roberts was torn. Here's a quote. He was torn between his heart and his head, where he wanted to kill Obamacare but thought it would be a bad idea. So he said, okay, I'll tell you what. I only want to kill part of the law, but not the other part. And originally, he was going to kill the mandate, but leave the Medicaid expansion in place. Then he negotiated a deal with Breyer and Kagan, like the same way you negotiate over a Turkish rug, right? It's like, okay, you come along with me, we'll kill part of the expansion for Medicaid, we'll leave the mandate in place. Who the hell does that? That's not calling balls and strikes, that's fixing the game. So I think Roberts has a lot to be ashamed of. And maybe this might be the case where he sets things right, although all I know is he always breaks my heart every single year. I will stop here, and I'll take as many questions you have. Thank you so much for your kind attention. Thank you. Come on, questions? Oh, come on. I was just speaking for 35 minutes. You have to have something.
Yes.
So, this isn't really related to the Constitution, but you briefly mentioned people who are undocumented or incarcerated. In your opinion, when is someone considered a public charge?
Oh, God, this question. So you're talking about this new immigration thing, right? Okay, so if I give the background wrong, just correct me on this, okay? So there are various federal laws that make it harder for people to adjust their status in immigration if they're so-called public chargers. And the Trump administration is suggesting that people who receive certain types of public benefits, food stamps, whatever else, might be public charges. Now, I don't think that people who are not citizens can get Obamacare subsidies. So I don't think there's an overlap between those two items. But certain states, I think California, are starting to give effectively health care credits to their immigrant communities. So that actually may play into it, but I don't think it's a matter of federal law. That's a good question. I haven't thought of that one before, but yeah. But in the statute, this was a huge, big deal. You might not remember this, but in 2009, when Obamacare was being debated, President Obama was giving an address to Congress, said, look, we're not giving insurance to people who are not here lawfully, right? And then a congressman from South Carolina, Joe Wilson, said, you lied. Remember this? He screamed out, you lied. And this was the exact issue they were talking about. But so the bill itself exempts immigrants from the mandate altogether, which also means they don't get their subsidies, because you only get the subsidy if you're subject to the mandate. Sort of circular. But thank you for the question. Yeah, in the back? Okay, so the question, if you couldn't hear it, was could the president order the Treasury Department not to pay out the subsidies? I suppose he could, but it would have to work like this. If the president determines that payment of these subsidies are illegal, then he could cut off the spigot. In another context, he did cut off certain subsidies, but not to the customers, but to the insurance companies, right? He halted certain payments from insurance companies that were never appropriated. President Obama was making payments that, at least I think, were illegal, and Trump stopped them. Okay, so I think Trump was actually right to stop those payments, but the reason why this is all stupid is now the insurance companies can go to the Court of Claims and say, reimburse us for our expenses, they'll get their money. So it's basically an end run around. But we've not seen a president be so brash to say, I think these payments are unlawful, I'm not going to enforce them anymore. Usually presidents wait till courts say so. Even President Obama, who took the position that DOMA, Defense of Marriage Act, was unconstitutional, he continued to enforce it. I personally would be very happy if a president said, I'm not going to wait for the court, I'm going to stop enforcing it. I think we have too much of a court fetish. Right? The courts are not the only actors that can interpret the Constitution. Every federal officer takes an oath to the Constitution. That's significant, and I would be just fine with the president saying, I've determined this law is unconstitutional, not going to do it. Not going to do it. We've seen this in a limited context. I'll give you one. There was a case called Zivotofsky. Congress passed a law that said you must issue a passport to a person born in Jerusalem that says Israel. And presidents ignored it. They said, nope, we're not going to do it. We'll stamp your passport Jerusalem, not Israel. And then you're ignoring a statute. And then the Supreme Court said, no, no, no. You can do it, right? The president can ignore the statute. Doesn't have to follow the statute unconstitutional. So you have a case where the presidents are ignoring statutes because they think they're unconstitutional. So it does happen, but not in the context you mentioned. I wish it were true, though. I think it'd be fun. People's head would spin. It'd be fun for me, at least. Yeah.
So in your view, and this is kind of more to bring it back to the fact that the Obamacare was meant to fix the American health system, the American health problem.
Mm-hmm.
What necessarily would you say would be a better answer to it than Obamacare? I mean,
Yeah.
the reason it wasn't able to be repealed, the answer that was put forward was not necessarily a great one. So what would you think?
I love the question. You're going to hate my answer. I'm not a healthcare policy person.
Okay.
It's a fair question. I try very hard not to opine healthcare policy because I don't know what I'm talking about. It's this weird thing. I'll just take a step back. When the Obamacare litigation came up, all these healthcare scholars suddenly became federalism scholars, right? It suddenly became experts in the separation of powers. And all these common law professors became experts on health law policy. I'm neither. I feel the same way about immigration. I don't know immigration law, but I know common law. So I try to stay in my lane. All I can say is that the way Obamacare is developed, now that it has a mandate but no penalties, you have basically two tiers. If you're sicker, you can rely on the Obamacare protections, you get the subsidies. If you're healthy, you can buy outside the Obamacare marketplace and not have to worry about a penalty. So you basically have two tiers. And Congress is subsidizing sick people, and healthy people can get their cheap bare bones insurance. Is that terrible? I don't know. But people who need the care are getting it, and people who don't want it can buy something cheaper. So maybe Obamacare is mutated into something that maybe is more palatable to what society wants. Yes, in the back? Yeah.
How is it different from the individual mandate, and do you advocate on also doing that mandate?
Okay, sure. So there are two types, or there are a lot, but there are two primary mandates. One is a mandate on individuals to buy insurance, and there's also a mandate on employers to cover employees with more than 50 employees, right? So you have more than 50 workers, you have to give them certain insurance. The reason why the individual mandate was unconstitutional is Congress can't command individuals to engage in commerce. But if you are a business engaged in the commercial marketplace, yeah, Congress can regulate you, right? Congress can regulate how you handle your employees' retirement funds, their healthcare funds, et cetera. So I don't think there's any strong constitutional argument to a federal mandate to buy insurance. As a practical matter, most companies don't really feel it. Large companies already gave their employees insurance. Small companies are exempt. And the federal government gives lots of waivers for companies that don't comply with it to this day. In fact, the employer mandate had its greatest impact in the other Obamacare cases involving religious liberty, right? The Little Sisters of the Poor, Hobby Lobby. These companies who are bound by the employer mandate were also bound to provide certain contraceptive coverage, or at least pay for contraceptive coverage, or have it provided by others, or different flavors. So the employer mandate had a much bigger kick in the religious liberty context than the context of the individual mandate. But thank you for the question. Other questions? Going once? Going twice? No? Thank you all so much. Have a wonderful day. Thank you.